We acknowledge that this video was produced on the traditional lands for the Kaurna people, and we respect their spiritual relationship with their country. We also acknowledge the Kaurna people as the custodians of the Adelaide region, and that their cultural and heritage beliefs are still as important to living Kaurna people today. Welcome to the Office of the Public Advocate. The role of South Australia's Public Advocate is to promote the rights and interests of people who need support with decision making, to help people with impaired decision making capacity, their families, carers and friends, and to provide information to the community and all people of South Australia. The Public Advocate can be appointed as the guardian for adults with impaired decision making capacity. This appointment is made by the South Australian Civil and Administrative Tribunal, also known as SACAT. SACAT appoints the Public Advocate when there is no other appropriate person able or willing to assist the person with certain decisions. Embedding supported decision-making principles into guardianship practice is one way to ensure that a person with impaired decision-making capacity has a say about the decisions that impact their lives. Supported decision-making empowers a person with impaired decision-making capacity to make their own decisions, but with guidance and support. At the Office of the Public Advocate, we use a tool called My Life, My Wishes to understand and to document the wishes and will and preferences of the people we support. My Life, My Wishes is also available for members of the community to use when supporting a person with impaired decision-making capacity. It can assist them to document their circumstances and their wishes because they are not able to make a legal advance care directive. Where adults do have decision-making capacity, I encourage all South Australians to make an advance care directive, to record their future wishes and appoint a substitute decision maker while they can. This ensures that their wishes and preferences are documented, and they can nominate a trusted person, which is important, who knows them to make decisions for them in accordance with their wishes when they cannot make them for themselves. This video is about supported decision making and how we apply supported decision-making principles when working and supporting guardianship clients at the Office of the Public Advocate. By the end of this video, you should understand what supported decision-making is, the responsibilities of Public Advocate staff when making substitute decisions for a Public Advocate client, supported decision-making principles, and where to find out more about supported and substitute decision-making. So what is supported decision making? All of us need help making decisions from time to time. We make them frequently. This may be discussing or weighing up a decision with a partner, a friend, or consulting a subject matter expert such as a doctor, a tax agent, or other professional to help us arrive at a decision. Some people with disabilities or impaired decision-making capacity may need additional support with decision making, such as facilitating their involvement to participate in the discussions and decisions about their life. This may include presenting information in a different format or making other adjustments to ensure they understand the information to assist them to make a decision for themselves. In recent years, there has been a shift to recognising that everyone, including people with impaired decision-making capacity, has the right to participate in making decisions about their lives. There's also been strong support and recommendations about supported decision making in the Royal Commission into Abuse, Neglect and Exploitation of People with Disabilities and the Aged Care Royal Commission. This also aligns with the United Nations Convention on the Rights of Persons with Disabilities, Article 12, which is about equal recognition before the law for people living with disability. The Public Advocate can be appointed as guardian for a person by SACAT. In order for SACAT to consider the appointment of a guardian for a person over the age of 18, it must have medical evidence that a person does not have decision-making capacity. Once SACAT is satisfied with the medical evidence and the need to appoint a guardian, it will first consider the appointment of a private guardian. If there is no one appropriate to act in the role and no other appropriate order can be made, the public advocate can be appointed. Whether it's a private guardian or the public advocate, they are appointed as substitute decision makers and are responsible for the decisions for the person. While the SACAT order deems that the person does not have capacity, it is recognised that decision-making capacity can be dependent on a range of factors, including the type of the decision being made, how complex it is, how the information about the decision is presented, and the support provided to the person during the decision-making process. Even though the public advocate has decision-making responsibility, staff try and seek out the wishes and will and preferences of the person and support them to understand the decisions being made wherever possible. The principles to be observed under Section 5 of the Guardianship Administration Act 1993 detail the considerations for public advocate staff when making substitute decisions, along with the National Supported Decision-Making Principles that provide guidance. The principles to be observed under the Guardianship Administration Act require the substitute decision maker to consider what would, in their opinion, be the wishes of the person if that person was able to make their own decision, to seek the wishes of the person about this decision wherever possible and practical to do so, to also consider whether existing informal arrangements for the care and decision making for the person are working well, and if so, not to disturb those arrangements, and to make decisions that are the least restrictive of the person's rights while ensuring they are not placed at risk. The National Supported Decision-Making Principles are: all adults have an equal right to make decisions that affect their lives and to have those decisions respected. Persons who require support in decision-making must be provided with access to the support necessary for them to make, communicate and participate in decisions that affect their lives. The will, preferences and rights of persons who may require decision-making support must direct decisions that affect their lives. Laws and legal frameworks must contain appropriate and effective safeguards in relation to interventions for people who may require decision-making support, including to prevent abuse and undue influence. For more information and videos about supported and substitute decision-making, including a community version of My Life, My Wishes, visit the OPA website at www.opa.sa.gov.au and search supported decision-making. Thank you.